You are listening to the UPSC Radio Lab. The Supreme Court on November 13th upheld the former Karnataka Speaker's order of disqualifying 17 Karnataka MLAs, but struck down the period of disqualification that is quoted by the former Speaker. The disqualification was upheld under the anti-defection law. Back in 2018, a petition was filed to the President to disqualify 20 MLAs of the Aam Aadmi Party, which the President rejected. Does that come under anti-defection law too? Confused? Well, today in the UPSC Radio Lab, we see in detail of all the disqualification laws of an MLA. First of all, let us understand the meaning of defection. It simply means desertion of one side in favor of the opposing one. Or talking politically, it is an act of changing party allegiance or loyalty from the party on which a person got elected to a different party. This law, which was passed in the 52nd Amendment in 1985, comes under the 10th schedule. It lays down the process by which legislators may be disqualified on the grounds of defection by the presiding officer of the legislature based on a petition by any other member of the House. But how did the anti-defection law come about? During the period 1960 to 1970, the defection process by the members of an assembly peaked its time. The phrase Aaya Ram Gaya Ram became quite popular in Indian politics after 1967, after a Haryana MLA Gaya Lal changed his party thrice within the same day. A legislator is deemed to have defected under two conditions. 1. If he voluntarily gives up the membership of his party, or 2. He or she disobeys the directives of the party leadership on a vote. So if the legislator defies the vote, that is, either abstains or votes against the party's whip on any issue, can lose his membership of the House. Let us remember, this law is applicable to both Parliament as well as the state assemblies. Are there exceptions to avoid disqualification under the anti-defection law? Of course there is. The law allows a party to merge with or into another party when there is at least 2/3 of its legislators in favor of the merger. In such a case, the 2/3 who want to merge with another party, as well as those people, the rest of the 1/3 who want to remain with the original party, will not face disqualification. I repeat, the law allows a party to merge with another party or into another party, that is, provided there are at least 2/3 of its legislators in favor of the merger. In such a condition, 2/3 who want to merge and the 1/3 who want to remain with the original party will not face disqualification. This ratio of 2/3 of party members or legislators came with the 91st Amendment Act in 2003. Originally, the law defined defection by 1/3 of elected members as a merger. 1/3, if they are ready to merge, they could merge and will not face disqualification. But it was changed to 2/3 in 2003. The anti-defection law is also applicable to independent members who were elected to the assembly and later joined a party. They stand to lose their membership as well. Voluntarily giving up their membership can mean when a legislator engages in anti-party activities like criticizing the party on public forums or multiple occasions, attending rallies of opposition party, etc., will automatically lead to voluntary giving up of their membership. The disqualification is undoubtedly decided by the presiding officer of the House, Speaker in Lok Sabha or the Chairman in Rajya Sabha. As far as the decision of the presiding officer and the judicial review is concerned, we have had different opinions. The law initially stated that the decision of the presiding officer is not subject to judicial review. In 1992, the Supreme Court struck down this condition, thereby allowing appeals against the presiding officer's decision in the High Court and the Supreme Court. But with a twist. The Supreme Court said an appeal cannot be registered until the presiding officer gives his or her order. That is, judicial intervention cannot take place until the presiding officer gives his or her order. That said, does the law specify a time period for the presiding officer to decide on disqualification plea? The answer is no. And as there is no time period, the courts have to wait until the presiding officer takes a decision to intervene in the matter. Often, this delay in decision making has resulted in members who have defected from their parties continuing to be the members of the House. There have also been instances where opposition members have been appointed as ministers in government while still retaining the membership of the original parties because there had been a delay in the decision making. With regard to the recent ruling, let us understand the main points. 1. The decision of the Speaker to disqualify has been upheld. 2. The period for which they have been disqualified was struck down. The Supreme Court said the Constitution enables the Speaker to decide on the disqualification of the members, but not on how long they could be disqualified. And hence, now the disqualified MLAs can contest on the elections that's going to be conducted on December 5th for the 17 vacant seats. Sometimes, an MLA can be disqualified even without resigning if by his conduct the chair concludes that his conduct has led to his voluntarily giving up his membership. When a legislator is disqualified, automatically Article 164, Clause 1B comes into force. That is, a member of a legislative assembly of a state or either house is disqualified from being a member of that house under the 10th schedule, will also be disqualified to be appointed as a minister for a duration of a period commencing from the date of his disqualification till the term of his office as a member would expire, or when he is ready to contest any other election. That is, right now if these 17 MLAs have been disqualified under the anti-defection law, they cannot hold the post of a minister from the date of disqualification till they are being re-elected. Let us just think of an ethical question. Does the anti-defection law affect the ability of a legislator to make decisions? The anti-defection law seeks to provide a stable government by ensuring the legislators do not switch sides. However, this law also restricts a legislator from voting in line with his conscience, judgment, and interest of his own electorate. Under such a situation, a legislator cannot vote what his or her constituents want them to vote for. Rather, he has to vote based on the decision taken by the party leadership. Is anti-defection law the only way of disqualifying an MLA or an MP? No. There are other provisions for a legislator to be disqualified. They are: 1. If they have charge sheets against them; 2. If they are bankrupt; 3. If they are insolvent, that is, they are unable to pay the debts they owe; 4. If they are convicted by the court for a particular case; 5. If corruption in the election process has been proven; 6. Unsound mind and stands so declared by a competent court; 7. He is not a citizen of India or voluntarily acquired citizenship of a foreign country, or is known to have acknowledgement of allegiance or adherence to a foreign state; and 8. If legislators hold office of profit; 9. He or she can be disqualified by or under any law as in such made by the Parliament. The Supreme Court rulings from time to time have come up with their own interpretation. Like in the latest ruling, the Supreme Court has said the Speaker acts as a quasi-judicial authority, and the scope of Assembly Speaker's inquiry is limited to examine whether the resignation of the MLAs was voluntary or not. So this is the capsule of the anti-defection law and other disqualification laws of an MLA for you. Thank you for tuning in, and see you in the next episode. You are listening to the UPSC Radio Lab.